guess it shouldn't be a surprise, Your Honor, Mr. Dulos is deceased. As a result of that, the state is entering a nolle in these three matters.
And Judge, on behalf of Mr. Dulos, Attorney Smith and I object, and we object for the following grounds. The practice book gives us a right to object to a nolle, unless, of course, it's a missing witness nolle. Mr. Dulos is dead. Mr. Smith and I observed his death and the declaration of death at 5:32 several Thursdays ago in New York State. But he's not a witness that was contemplated by the statute. Mr. Dulos was always unavailable to the state on Fifth Amendment grounds, so a missing witness nolle is inappropriate. The fact that the defense has a right to object is an implicit recognition that there are two sets of competing interests at a criminal trial. The state obviously has its interest in specific and general deterrence, in rehabilitation, in punishment, and in protection of society. But counterbalanced against those is the defendant's reputation plus interest, a right recognized by such cases as Wisconsin v. Roth under the 14th Amendment. And on behalf of Mr. Dulos, who manifestly and steadfastly maintained his innocence, and on behalf of his estate and his memory, we want to vindicate that interest, and we would like to go to trial. Should the case go to trial, there is no question in our mind that he would be acquitted. We understand the circumstantial nature of the state's case, but we find certain elements of the state's proof to be shocking, and certain ways in which the state proceeded to be startling. For example, the second warrant filled with law enforcement beliefs about Mr. Dulos in a red truck. There is no evidence that he was ever in that truck. Indeed, we don't believe he was. In the course of representing him over the last 8 months, we entertained every realistic possibility that we thought had some support in the evidence. As recently as 2 months ago, we've received reports of sightings of Ms. Dulos. We have no credible evidence to suggest she's alive, but we can't be faulted for pursuing every lead. If the case did go to trial, Judge, we would have proceeded under the theory, and we have reason to believe that this theory is in fact true, that Ms. Dulos came to a violent end at the hands of third parties unrelated to Mr. Dulos. That as to his disposal of certain items in the Hartford area in the day of her disappearance, he left his home at one point in that evening and saw a third party known to the participants in this trial standing near a pile of debris in his yard, and he panicked and disposed of that debris. While he may have had suspicions about what that debris was, he did not, in fact, knowingly dispose of items that were associated with a pending investigation.
Judge, I want to not turn Pattis off, but cut him off. I believe he's objecting to the nolle, so in light of that, I'm going to move to dismiss the matters.
I'm entitled to make my record as to the basis of the objection, and I'm doing so for purposes of appellate review. We've been.
Pattis, could you finish up, please?
Yes, sir. So we don't believe there is, while we believe that there may have been probable cause to initiate an investigation of Mr. Dulos and to bring the charges, there really is no question in my mind that had the case been tried, he would be acquitted. His suicide note made it clear we were in possession of evidence. We've reflected some of it here, not all of it. We're going to ask the state for permission to bring an action against the state under the Claims Commission for its transformation of warrants in this case into the functional equivalent of what our law does not recognize, that is an investigative grand jury. And it is our hope that we will someday, somewhere, get a fact finder to listen to all the facts, all the evidence in this case, because when it happens, they will conclude that Mr. Dulos was not only not guilty of a crime, but was himself the victim of a conspiracy so immense that in the end it drove him to despair and to take his own life. So for those reasons, we object to the nolle.
All right, the state has broad discretion on whether to proceed on prosecution. The state's entitled to the nolle case. Nolle's noted. I have no jurisdiction to do anything else. Do you have anything else?
No, Your Honor.
Okay, thank you. Nolle's noted.
Thank you, Judge.
Thank you, Your Honor.